budget process. We are going to try to go through this agenda by 1 o'clock, so Senator Negretti McLeod can meet her appointments after that. Also, I'm told that Senator Harmon won't be here. So we'll first take up the vote-only items, and out of courtesy to Senator Harmon, he's asked that item number 2 under the Department of Justice be held over. That's the gun show program's augmentation. So we will do that to when a subsequent hearing when Senator Harmon can be here. Other than that, unless I hear any signal from the rest of the committee, the much esteemed Senator Negretti McLeod, we will assume that that's a 2-0 vote to approve the rest of the vote only, with that noted exception, with noting that Senator Harmon is absent. And with that, then we will go to the rest of the hearing, and I would ask the Department of Finance, the appropriate folks, maybe you can take a seat up here. The LAO, if you can maybe come up where you can be close to us. And we will start with the alcohol beverage control and begin with item number 1. And on all of these items, except for perhaps one when we get into corrections.
Is it okay if they move up here? No.
Yeah. Sure. So Senator Negretti McLeod, in spite of the fact that she wants to stay as far away from me physically as possible, has... No? Okay. Finance is here, LAO is here, Department's here. The process will be that we'll hear from LAO first, Finance, and then the Department, and then we'll entertain any discussions or direction from the committee. We will have public comment at the end of the whole process, and I'm anticipating that there'll be public comment under corrections item, particularly mental health, so we'll have that after that. But for this, we will start with the LAO on the liquor license fee recommendation.
Russia Chavez with the Legislative Analyst's Office. Mr. Chair and members, the issue before you today regards fee increases on some liquor licenses that are assessed by the Department of Alcoholic Beverage Control. For the purposes of our conversation today, I may be using the acronym ABC. The governor's budget proposes to increase general license fees from $12,000 to $13,800 in the budget year. The fee increases on this fee have not been increased since about 1995. In addition, these fee increases are expected to generate about $400,000 in the budget year. And essentially, there's another fee increase that we will be talking about in a little bit in the second item that's similar to this one.
Mr. Chair.
Senator Negretti McLeod.
In our analysis, it says that the increase would be an estimated $788,000, not $400,000. So is there an error? No.
LL?
That's not an error. That is actually including the out years. Our number represents the one that will be enacted January 1st.
Okay. Want to continue, or have you concluded?
Concluded.
Okay. Finance, any comments? Don't feel obligated if you have nothing to say.
Scott Sanders, Department of Finance. We concur with the fee increase.
Thank you. Department? Any comments?
No, sir. It is what it is, and it's for half a year, and then it'll take over full-time July 1st.
Okay. Senator Negretti McLeod.
Mr. Harvey, has there been a hue and cry from the owners of the licenses that this would break them or whatever, that it would hurt them at all?
No, we haven't. We had an increase about a year ago, and I only heard from one person on it, and they really want the ABC to be out there doing the job, so we haven't heard any kind of an outcry at all on this.
Having some experience with this, having been a license holder for on-sale licenses before I came here, and having tried to get them through the lottery in the East Bay and failing and having to pay market rate, these rates are lower than when somebody goes out and buys them outside of the department with your approval. And I would guess probably by $20,000, $25,000, maybe in some instances. Less.
Sir, Tim Gorsuch with Chief Deputy Director. In El Dorado County, they can go for up to $250,000, depending on the need and how often the state actually sells these licenses in those communities based on the population growth. So the $12,000 is extremely low when it compares to those types of markets. But in some locations, in the Central Valley, $12,000 is still a lot of money, and people can't afford to buy them there either.
Right.
So it depends on what marketplace we're talking about.
So just so my colleagues know from my vast experience as a restaurant owner that I'm thankfully retired from, hopefully I won't be going back into it. Most of the, when you open a new business, most likely you're going to buy it from a broker or you're going to buy it online or something, and you're going to pay what the market will bear. When there's a calculation that you have that's statutory that the population increases in a county, then you have a lottery, and that's when this price comes up. So it strikes me that most people do this lottery because they know, in most instances at least, except for maybe some counties in the valley, this is a cheaper way to get a license and open a business. Is this for on sale and off sale, or is it just?
$12,000 is the license you're speaking about.
Yes, but it is for both categories, on sale and off sale priority.
Well, the suggestion is to hold it open to see if there's any comments out there from the community, because we do want to, committee wants to be sensitive to the business community, to see if there are any more comments than just one. But my inclination, we will hold it open based on the recommendation, if it's okay with the committee, and you'll come back, and hopefully if you have any more input, let us know. But just from my personal experience, I think the context of you need the revenue to provide the services to oversee the proper applications of the license. You're stretched thin, and from my perspective, it would be a good investment.
Thank you, Senator. It really, it's a fee or a tax, depending on how you see it. And we're very appreciative that the administration is okay with this, because otherwise it would not happen probably. And we're not doing a lot of it, because we're very aware of the times. And I should introduce myself, sir, as Steve Hardy, the director. Tim Gorsuch is my chief deputy. And Ed,
jump in here before you first by your boss.
It's terrible. I mean, he's been with us 3 years. And
I always tell people when I can't remember their name, that's a good thing, because I remember people who are in trouble, not people who are doing a good job.
Yeah, but I remember him for good work, so I'm really embarrassed. Ed Jimenez,
right,
sir.
Welcome, Mr. Hernandez.
Yeah, whatever.
Okay, if there are no further comments, then it'll be held open. We'll ask you to come back with any other comments you may receive from anyone in the public. We might ask the California Restaurant Association, the retailers, if they have any comments, but their absence here and their continued absence wouldn't lead me to believe that it's okay to go ahead. But it will be held open. Item number 2, we actually have a recommendation for approval. So this is on ABC catering and event authorization fees. LAO?
This issue is related to the first one, as mentioned, and it's to increase the catering and special event fee authorizations from currently $10 to $25, and in the budget year is estimated to generate about $128,000.
Okay. Finance?
We believe the increase is appropriate.
Department? You have within your grasp an approval, so.
Thank you. Thank you very much.
Anything else?
On this one, no. We're just appreciative of the fact that we can have support about it.
Any comments from the very intelligent committee members present? Good. Okay. So unless I hear differently, we will accept staff's recommendations and approve the request and go on to Department of Justice. So thank you. Thank you all for coming.
Thank you.
As Department of Justice comes up, once they're seated, we will take public comment on ABC if there is any. Go ahead and let's get seated, and then we'll just take a brief time out. So Finance is here, LAO's up front, and DOJ is in the hot seat. On ABC, is there any public comment or testimony? See, Brian, I knew that intuitively. All right. First item is Legal Services Fund Swap. LAO.
Drew Soderborg, Legislative Analyst's Office. DOJ provides legal counsel to most state agencies that require legal services. While some state agencies' programs are billed for the services provided by DOJ, DOJ has a general fund allocation in their budget to support its legal services on behalf of agency programs that are themselves supported by the general fund. There is some concern that the agencies that do not have to pay for DOJ's legal services do not make efficient use of them. Also, recent reductions to DOJ's general fund budget have resulted in DOJ turning down workload from some of these departments and authorizing them to seek outside counsel, which is generally more expensive than that provided by DOJ. The governor proposes eliminating the general fund used to support DOJ legal services on behalf of these agencies. This funding would instead be allocated to agencies seeking DOJ legal services through a new control section in the budget. The proposed budget bill does not appropriate these funds, however. Essentially how this control section would work is that agencies would make a request to DOF, who would then consult with DOJ. After approval, agencies would reimburse DOJ for its services with the money by depositing it in a legal services revolving fund. The legislature would be informed of the allocations after they occur on a quarterly basis. The administration is proposing using the information collected through the control section process to eventually permanently adjust agency budgets to include general fund allocations for legal services. It is hoped that this will prompt agencies to use these legal services in a more cost-efficient manner. The governor's proposal has merit because it would provide agencies a way to use less expensive DOJ legal services in years where the state's aggregate legal service funding is not sufficient to cover agency needs. In addition, by requiring DOF to approve requests for legal services, it would help ensure that agencies do not make excessive use of DOJ legal services, and it may prompt agencies to use in-house counsel or settle cases if that's more cost-effective. In addition, by eventually moving funding to individual agency budgets, the proposal may indeed prompt agencies to use more DOJ legal services more efficiently. However, because we feel there is insufficient legislative oversight of the process, we recommend several different changes. First, we would recommend that the language be adopted requiring that requests above $1 million be approved no sooner than 30 days after notification is provided to the Joint Legislative Budget Committee. And we'd recommend use of the control section process only during 2010-11 and making ongoing adjustments in agency budgets in May 2011 for the 2011-12 budget as a way to try to move up the date at which these funds would be put in individual agency budgets. Also, we feel that the proposal needs a technical fix because it does not appropriate money for legal services anywhere in the budget. Accordingly, we recommend that the legislature appropriate the $48 million in legal services in an item within the budget.
Thank you. Finance.
Teresa Calvert, Department of Finance. We don't have objections to the LAO's recommendations in general, but we would like the opportunity to work with the LAO and legislative staff on the technical details of those recommendations.
Okay. Department.
Mr. Chairman, Dave Harper on behalf of the Attorney General. I think the analyst is fairly accurate in his description of the proposal along with the comments in your agenda. Our department, we have a fundamental disconnect in how we provide services for our general fund clients versus our special fund clients. And one of the unintended consequences of that disconnect is we've opened up about a $30 million operating deficit for our general fund clients. Because we're talking about defense work here, we have really no ability to or discretion to control that work. We work for our client, and the actions taken are on behalf of the client. So unless we can find a way to get the client more involved in the decision-making process, we don't see a way to fix this operating deficit short of just coming to you and asking you for the money. And that's not what we want to do. That's not what's in the best interest of government.
So I guess I just play a little devil's advocate. I'm just worried about shifting the costs, and I prefer to have, based on a hearing we had with corrections, just about an analysis of whether it's worth pursuing a case. I mean, when you're obviously defending the state, you have to do that. But an analysis of what it's going to cost, and maybe a template that you could talk about. Maybe there are some out there within departments, or there may be in the Department of Justice, But I go back to my local government roots, those painful closed sessions where basically you would go to county council, and if you had an outside attorney, they would give you a percentage on, if you go to trial, this is the best strategy to defend it. And I assume those discussions take place.
I can't tell you that they take place in every instance. Generally, when we hear about the case initially, it's because the client, the State Department, has been served with some type of an action. So ways to avoid that service all really occur at the department level. We can consult with the client, suggest possible remedies, suggest possible settlements, but at the end of the day, it's the client's call. We can't force them into a settlement that they don't agree to.
Right.
So we're hoping that this proposal will start that discussion. We'll start the clients thinking more about what is the highest and best use of that limited general fund resource.
And I agree with that. I just wonder if maybe there could be a little discussion about, are there models out there that sort of meter the process so that we make sure that there's a proper fiscal oversight. And I get the fact that, and I'm not criticizing the recommendation. I think it's a good idea, but maybe there's a process not just to shift it back to the departments, where some departments might just say, okay, we're not going to get the money. We know we have to take it out of our own budget, which I think is appropriate, which is a suggestion. But on top of that, maybe the lawyers, the Department of Justice, is the proper place for them to seek advice of what's the best strategy to defend this, and when do you seek settlement, when do you, so something like that. I'm not a lawyer, but in a simplistic view, I just wonder about how people determine when best is the best time to not spend a lot of money on defending a case. And I hated settling cases in local government, but sometimes you were just forced to because the risk of going to trial in many instances was not worth it. And I assume that there are conversations, but I wonder if we could at least have a discussion about a template about maybe the DOJ offering that isn't very expensive.
Right. We'll go back and look at the issue internally. I know that collaboration you talk about probably exists with our special fund clients, right, because they're paying for our services. Right. But in the sense of a general fund client where it's easy, I'm going to oversimplify this, it's easy for the general fund client to simply say, litigate everything, because at the end of the day, they're not paying for it. It's coming out of our budget. Right. So
I want to be clear. I think it's an intelligent thing to do what is being recommended today, but maybe when we come back, if there's some back of the envelope look at not just shifting the cost, although intuitively you would obviously assume what you're assuming. If the department's responsible for the cost, they're going to be more circumspect anyways.
Absolutely.
Okay. Any questions or comments from the committee?
I have a question.
Your muzzle is off.
It says here in the staff analysis that the DOJ actually billed for 456 plus hours, and at 170 it comes out to $77 million. But yet actually you're only asking for $48 million. So where's the remainder of the money if that's an average of what you're using yearly?
Senator, thank you for the question, and that's precisely the issue we're trying to solve. We're doing $77 million worth of general fund work on a budget of $48 million. And unless we can find a way to incentivize our client to drive that cost down, we're simply going to be at the mercy of the client, come back to you and ask for more general fund resources. We don't have the staff available to continue to do $77 million worth of work.
Do you find that some departments don't take seriously when they have legal things filed against them, that they just kind of let it sit? Would it be more expeditious if they took care of it quickly? Would they settle stuff sooner? Would it be more cost effective? What do you find?
So I'm not willing to say they don't take it seriously. I think every client takes the litigation seriously. I think it gets back to this fundamental disconnect that if you're getting free services from us, you may not have an eye towards cost. And if you're paying for those services, like our special fund clients do, you're more invested in what is the best overall strategy for any given case.
Do you find that much of what comes before you is employee-driven because of some management style that causes this over and over? Have you seen that kind of a trend?
I wouldn't say it's employee-driven trends. I think the elephant in the room is the work we do for the Department of Corrections across all of the gamuts of that department, and we're so simply overwhelmed by that work. We just don't have the resources. So all of the conditions you address within the institutions and all of the special masters and all of the various class action cases, that all lands on us to defend. And so we're constantly defending the operations of the department, the discretionary decisions of the department.
And, Mr. Chair, that kind of goes back to that hearing we had where it dragged on and the cost kept rising and escalating. So, okay.
Which goes to some of what I was getting at, but the other part of that just occurs to me, though. So in order to correct the situation after we've defended the lawsuit, how do we know that departments are going back, and this may be a subject of another hearing, how do we know the departments are going back and doing corrective action so we don't have subsequent lawsuits over the same mistake over and over again?
I think you would have to ask the individual departments. Depending on what the type of case is, if it's a class action case, the Attorney General may play a role in monitoring the conditions or the agreements of the settlement. And that monitoring may occur over a number of years, but actually correcting what was litigated and what was resolved really falls back on the department.
But is there any process that you're aware of that goes through the Attorney General's office to look at corrective action that might come to the legislature, or should we be doing that with the individual departments?
I'll check. To my knowledge, there's not a process currently, so it's simply as the clients bring issues to the legislature for consideration of possible funding, that's when you determine are they complying with any given settlement decree.
So we really have the two issues, one of things dragging on, and when is the right time to seek a settlement, and the other question, I think, is what do we do about correcting it after it's settled or as soon as the subject comes up and we find that there are faults?
That's exactly right. And I think that's even the bigger point is that when you know about the condition on the front end, you may decide to take the action to solve the problem initially and spend the money to solve the problem instead of spending the money to litigate it and then spending the money again to solve it.
So that, is, I assume, is part of questions about settlement. So I know that in the Department of Corrections, constant communication either through the lawyers or the clients themselves on, we'll settle this if we take care of this in this manner. So it would be helpful, I think, for the legislature, and maybe when you come back we can have some suggestions between the LAO and Department of Finance and the Department of Justice how best we would get that information, and again maybe we create some kind of template so that the legislature knows that there has been corrective action taken so there aren't subsequent lawsuits.
So we don't get this every time in the budget.
Or the people who come behind us.
Exactly.
The concern about, since you brought up the elephant in the room, and since Mr. Harmon, the one Republican, isn't here, we won't make any party mascots. How do you make sure, that the money that's left there as we change doesn't all go to one department? The smaller departments get their fair share.
So I'm going to defer to Department of Finance because they would be actually doing the allocation of money.
Part of the allocation process would be looking at the individual departments' budgets to see what they have as far as resources available for legal services. We'd be working with DOJ to get a good understanding of what is the likely workload for a particular department, and also looking at having departments re-examine their legal workload as it exists now and seeing if there are perhaps efficiencies that can be gained there and things done differently. So it is going to be a difficult process. We know that CDCR has the largest share of these hours currently by far, and we plan to make, at this point, quarterly allocations at the minimum, and it could be even more often than that to kind of spread out over the year the allocations to all the departments and looking at the individual departments to see what the highest priority is.
And what the cost might be ultimately to the general fund.
Correct.
So we drive people out to hire more expensive attorneys. That's a concern as well.
Exactly. And when you hire the outside counsel, they have a profit motive in that relationship, and the Attorney General doesn't have a profit motive.
We shouldn't get to the motivations of the Attorney General. So I think we have a few things, hopefully, that you can come back to and help us with.
Absolutely. We'll work with your staff to kind of make sure we have the appropriate attorneys at the table to answer your specifics.
It strikes me what we're after here is fairness for all the departments, responsibility connected to the costs and the department, so they'll assume that, and then maybe at least the legislature being able to better monitor what the costs are, but also the cost avoidance. Once we've learned the lawsuits happen, how do we make sure that we're not sued again? And then the other issue of when's the right time to settle.
Absolutely.
Okay, great.
Thank you, Mr. Chair.
Do we have any public comment on this item? Come on up. You may have a seat at the 2 empty seats, and we'll just I'd like to ask you to try to be about 2 minutes in length so that we can get done in a timely fashion. Go ahead.
Thank you, Mr. Chairman and members. I'm Sarah Christie, the Legislative Director for the California Coastal Commission. We don't generally appear before your committee, but there are several cross-cutting issues that we're very concerned about with this proposal. The Coastal Commission is one of the non-billable agencies that would be affected by this fund shift, and we would like to point out that essentially none of the justifications that are given for this actually apply to the Commission. We've never been turned away because we've exceeded our budget with the Attorney General. We've never had to hire outside counsel to represent us in litigation. And we already work very closely with the Attorney General in terms of deciding which cases to bring forward, which cases to appeal, and which cases to settle. Unlike many other state agencies, we do not have administrative penalty authority, so we don't have the luxury of settling a great number of our enforcement cases outside of the litigation process. And this proposal would significantly, we are concerned that it would significantly weaken our litigation and our enforcement programs. The point that was brought up by the committee that for the potential for other departments to sop up all of the allocated money in the pool is a great concern to us. And we would suggest that if the legislature is concerned with increasing transparency in terms of how general fund money is spent on litigation, that there are other ways to accomplish this. In addition, we want to point out that there would be more costs associated with the workload that this implicates for the Coastal Commission. We would have to hire additional counsel to oversee the case management workload that is required for this kind of an arrangement with the Attorney General. The likelihood of that happening is very low, which means we would have to reallocate existing legal staff time to be doing that, and that's coming out of a legal division that's already suffered significant budget cuts in the last few years. We would request that if the bulk of this problem, as we understand it, is being generated from Department of Corrections, we'd like to suggest that this committee perhaps confine its very legitimate discussion of this issue to the Department of Corrections. If that's not acceptable to the committee, I think there's a very strong policy argument to be made that the Public Rights Division within the Attorney General's office as a whole should be excluded from this, because the type of litigation that the Public Rights Division does is fundamentally different from the other types of litigation that are driving this problem. We don't get sued, we're not the case, we don't have class action suits, we don't get sued for inappropriate use of force or inappropriate application of medications. We get sued for essentially commission actions to defend the public's rights, the public access to the coast, the public rights to clean air and water, those sorts of things. If we're having to make decisions about whether or not to defend those actions based on a limited budget that's approved essentially through the BCP process, it's the public rights that are truly going to suffer as a result of this funding shift. I really want to underscore that we do work very, very closely with the Attorney General's office, and there are cases that we discuss that we don't take forward. There are cases that we settle, but from our perspective and the staff, the deputy AGs that we work with, this would have a significant deleterious effect on our ability to continue to protect the coast, and we would strongly urge that that we be exempted as part of the Public Rights Division from this proposal.
Thank you. Points well taken, and maybe we can include some comments when we come back from the LAO and from the Department and Finance.
Thank you.
Good morning, Mr. Chair.
We know that you never have any controversy at the California Coastal Commission. Yes.
Good morning, Mr. Chair and committee members. My name is Mario DiBernardo. I'm the legislative liaison, but also staff counsel for the State Lands Commission, and I thank you for allowing me to comment today. I agree with many of the points that Ms. Christie from the Coastal Commission made. I'd like to add that if enacted, this micromanagement of the DOJ's budget could potentially prevent the State Lands Commission from defending and enforcing several lawsuits involving the state's public trust lands. The Commission, as part of the regular course of its business, enters into leases and contracts involving the state's coast and navigable waterways. As the nature of leases and contracts, there are often breaches, and these breaches can only be resolved through litigation. That's not to say that we don't do our due diligence in settling the case, and in fact, I'm working on one case in Malibu where the threat of litigation has actually led to some serious settlement offers. Additionally, because of the ambulatory nature of the state's waterways, the Commission deals with legal issues involving trespass, boundary line, and title disputes on a normal basis. In one of our recent cases, the AG's office spent over 12,000 hours working on a case that settled in favor of the state for tens of millions of dollars. In many other cases, the Commission's threat of litigation led to settlements. Additionally, the deterrent effect of the litigation threat is immeasurable. By putting such a specific cap on the Commission legal services could lead to fewer settlements and less deterrence. Lastly, the Commission was created in the 1930s as a result of corruption involving oil and gas leases in a division within the Department of Finance. By giving the Department of Finance such control over the Commission's litigation budget opens the door for potential future mischief. And as the LAO's analysis states, there's a lack of oversight within this proposed process. As such, I respectfully request that you oppose this budget proposal. Thank you.
Mr. Steinhardt, how are you?
Fine. It's David Warren, though. Close enough.
Close. Sorry.
I'm appearing on behalf.
We go back. It's a recurring theme today.
Yes. I'm appearing today on behalf of taxpayers and improving public safety, and we oppose this proposal, and we provide two examples because we believe the Department of Corrections needs outside counsel to provide advice. The first example is that the Department of Corrections was sued to provide kosher meals for inmates, and after many years there was subsequently a settlement. Now Muslim inmates have filed a lawsuit to obtain halal meals, and there have been numerous actions all over the state, and one in which the federal judge ordered kosher meals be made available to Muslim inmates. The cost of litigating this under RLUIPA, instead of having outside legal advice saying you're going to lose this, might as well go forward, makes no sense, but the Attorney General's office digs in their heels when it comes to inmates. A second example is when it comes to parole hearings. The California Supreme Court has set standards for the release of inmates under the Davis-Lawrence decision and Chaputis, and yet routinely the Board of Parole Hearings says we don't care, we're going to follow our own dictates, which generates a tremendous amount of litigation. Outside legal counsel will assure that settlements come early instead of litigating all the way to the Supreme Court. So I believe it's very important under these situations that outside counsel be the preferred choice rather than the Attorney General. Thank you.
Thank you, Dan. Anyone else on this item? All right, so I think we've got some direction. A couple of points on public comment it would be nice to have a response on, particularly the Coastal Commission and Land Commission's asked that they be somehow exempted from this, and the concern of actually adding the cost if there's any kind of analysis or opinion. I assume everybody from the Department of Finance from the 30s who was involved in that those cases are gone.
To my knowledge.
Yeah. Okay, thank you. I'm sorry, did you have something?
Oh, no. If you wanted us to respond to any of their points, we could do that now. Did you want us to do that now or?
Briefly.
The only thing I was going to say is that there's already a finite cap on DOJ legal resources because they're appropriated within DOJ's budget. It would be up to both the legislature and the Department of Finance to make sure that the allocations that they make to individual agencies would be an appropriate level to support that agency's work. Also, agencies would later be able to request that their budgets be adjusted through the subcommittee process. And so in the future, when individual agencies have the budget or have the funding in their own budget, the subcommittees that are familiar with the policy work of the agencies would be able to assess whether or not they need more or less funding.
Good. So. Did you have something to add?
Jennifer Osborne, Department of Finance. I just wanted to follow up on the testimony as well, that we had actually spoken with the staff of the Coastal Commission about this issue, and they've expressed similar concerns. And we pointed out to them that they're actually, because they do have a great relationship with the AG and also are fairly, according to them, very closely connected with what goes on, we think that they would be a great candidate for this and really don't believe it would affect their operations at all.
Yeah, Mr. Chairman, I'd like to just follow up on that. I think the testimony from the Coastal Commission and even the state lands shows you what is possible when you have that relationship, and that they ought to be used maybe as the model of what could occur with the rest of our general fund clients. It does work. Fiscal responsibility by the client does work. We just need to put the process in place to help it work.
Okay.
And then the final comment about using outside counsel. This is a fiscal committee, and the fact is outside counsel is more expensive than what we would charge a general fund client at an hourly rate. Now, there may be policy reasons to use outside counsel, and I'm not going to discount those policy reasons. But as a matter of fiscal policy, we do the job better and we do it cheaper than outside counsel.
Well said. Any other comments? Thank you. Appreciate it. We will look forward to you coming back with a refined solution. Next item, we go to the California Department of Corrections, and we'll start with item number 1, oversight of the Department of Juvenile Justice reentry and parole programs. And in this instance, staff has suggested we start with the department because you're special, and then we'll come back to the LAO and finance. Good morning, whenever the department is ready.
Good morning. Dave Lewis. I'm Deputy Director of Fiscal Services for the Department of Corrections and Rehabilitation. The department proposed $48 million reduction to the Division of Juvenile Justice related to changes in the way that we house certain of our offenders. The 3 specific proposals were limit the age of jurisdiction to 21,
Mr. Lewis, I think you're ahead of us.
Oh, sorry.
We don't want that to ever happen. So we want to start item number 1.
Reentry and parole.
Is reentry and parole.
Good morning, Chairman Saunier and members of the committee. I appreciate the opportunity to talk about parole and reentry. Often in juvenile justice, we focus on our institutions and the federal litigation, so it's a good opportunity to talk about transition and parole. And I have with me Rachel Rios, the Director of Parole, who will talk shortly about the model in place. But what I did want to provide to the committee is that the reforms within juvenile justice are broad in that they is a continuous case plan. They're built on the principles of effective intervention, which I would say is a national best practice, that we have developed a risk need assessment that allows us to target our population, to develop individual case plans, and to target programs for those youth with highest risk. So in the implementation of our reforms, we have focused on facilities, but we are evolving those reforms into the community, which Director Rios can share. Most of the reforms that are part of Feral are embedded throughout DJJ, and we think will get us the reductions in recidivism that we would like. So I would like to have Ms. Rios briefly talk about parole and reentry.
Good morning. Let me start by saying that, first of all, you have a very thorough report, and so I won't go over everything that's in the report, but I do want to share a couple of things about what we are doing in DJJ parole. Last year in 2009, we implemented a parole continuum of care model, which is a 6-phase model of care. 3 of those phases are before a youth is even released from custody. So we start the parole planning at the very beginning, at the time of commitment, by going out and doing the community assessment report. We stay engaged with that youth and try and engage the family during their detention phase, and then we look towards preparing for that transition early on rather than 3 months before release, looking at an earlier transition phase, 6 months. We are working with a lot of the groups, a lot of the federal plans that also have transition placements in their plans. Education, for example, has transition in their plans, sex behavior treatment, mental health, and we're working with all of our partners, including facilities, to develop those transition plans earlier so that when youth are released to the community, we have a more seamless opportunity for their success. Some of the other things, when they are released, we are looking at a parole continuum where we do not keep youth on parole through the end of jurisdiction, where we're looking for a case plan that focuses our services on their risk needs and what their highest risks to reoffend, and that once they've addressed those needs, that we look for positive outcomes and recommend for discharges. One of the efforts that we've recently undertaken to do that is we've started a statewide reentry task force, which includes collaboratives from all over California. We have folks from education, folks from county level, we have community-based organizations, and we're looking to that task force to help us in terms of developing our goals and to help us in terms of developing our measurements and how our parole continuum should look like. One of the other things that I really do want to acknowledge here is that parole was one of the litigants, as was previously discussed, and in the lawsuit that's commonly known as LH, parole implemented our reforms last February 2009. We have been in substantial compliance from the beginning of implementation. We are over 90% compliance in the last couple of months, which is really an extraordinary stride for a litigation, and so we're very pleased with those efforts. In terms of parole's success, one of the things that we do is we really focus a lot on the things that we're not doing, and we have not been focusing on the successes that we do have. So one of the areas that we are trying to implement is an opportunity to highlight some of our young people who have actually gone on and made some very positive and productive changes in their lives. We have a lot of young men who have come from our camps, who have gone on to become firefighters for our community, who've gone on to be Corps members, who have been recognized nationally, and we think that that's important that we share that information. So we are looking at putting together some numbers in terms of those young men and their successes. And I do know that you have some questions for me, so I'll give you an opportunity to address any of your questions.
I have a couple. Senator Grady-McLeod, you want to? Well, just in terms of recidivism, and I have here that we've got a rate of about 50%, if I'm reading it right, within historically the recidivism rate for DJJ wards released has been over 50% within the 2 years of release and about 3/4 of all releases. Do we have ongoing measurements in terms of trying to reduce that, and can you share those with the committee either now or when you come back?
Yes.
I can briefly talk about our process, Senator. We are very interested in evaluating the reforms in DJJ in terms of reduction of recidivism and positive outcomes. So what we first had to do, because of the changes in population around the realignment that occurred in Senate Bill 81, is make sure we were comparing the same populations over a significant period of time. So we have gone back and looked at 2004, 2005 of those serious violent youth who was a similar cohort who's in DJJ now. So the numbers you're referring to in terms of their recidivism are for those youth who really were part of the system before the reforms have taken place. But we are continuing to evaluate those longitudinally, and we expect that we will be able to compare outcomes and recidivism rates with our current population over a 3 or 4 year period of time. So these numbers only reflect 2004, 2005. And as youth move through DJJ system and onto parole, we'll be able to then track the outcomes and recidivism for that population.
Okay, well, I'll be very interested, and I should have said this at the top. We've got a letter going out from Finance that was approved by the Chair of Budget and by the Pro Tem for this committee to actually ask for certain things. You'll be getting that, and when you come back, I hope you can do as much as possible. It'll be an ongoing process, but I think in your case in corrections, and specifically for DJJ, we've got the challenge of what the courts want from you, the challenges of what we would like to expect of you within the parameters of our legal constraints or direction from the courts. So to the degree, and it's been a little frustrating for me, and it may be partially a reflection of being now a sophomore, but having watched Mr. Machado through tedious hearings and felt his frustration after having chaired this committee for many years, to have very specifically outcomes as to why recidivism, and I'm not, this isn't a get-you sort of process from my perspective. It's so that we can tell the public that we're making progress. And if we aren't, so the legislature and the public knows why. And if it's a legitimate reason, then we go to correct that. And it is sort of a medical model in my mind's eye. So when you come back, if you have that material, if you could bring it to us, and the sooner we could get it. And when there are your concerns about apples to apples, just if you could explain that in narrative form as you decide why you don't feel the measurements are correct. And certainly, Bernie, you've had this experience around the country, so why we have you here, we'd like to use your experience vis-a-vis best practices, knowing that California has very large challenges. So besides recidivism, it would also be helpful, at least for me to know, why they went back in, what kind of crime or violation they had, and to the degree you break those down, great. I don't want you to reinvent the wheel. And then what are the best practices you are pursuing either under LH or you're doing on your own? So if young people are going back into reentry, just use the simple example of, I know in foster care when kids get emancipated, if they have transitional support from spacing on the acronym. But if they have transitional support for the 6 months before they're emancipated, the probability statistically of not being reinstitutionalized is much higher. So I assume the same thing if we get these reentries, Ms. Rios, if you have a cohort or you have national statistics of these are the best practices in terms of what they need for reentry to be successful, then we'd like to hear those before we have, and this is also, we'll talk about this for the adult part of the Department of Corrections. What are we doing to make sure the public is as safe as possible as we're having these young people go back into the public?
And we do, Senator, have a range of performance measures. And so recidivism is obviously very important of reducing future delinquency, but we have performance measures which address increased safety in our facility, reduction in violence in our facilities, performance measures in terms of increased education, youth who get their GED or diploma or are enrolled in college. Those who, Ms. Rios has performance indicators about youth who are employed, youth who participate in counseling and treatment. So I think those are all important performance measures and benchmarks that we can share with the committee as well.
And one of the things I'd be concerned with as we go on this journey towards performance-based budgeting that I hope will be successful here and more outcomes is getting those numbers right, but also having them truth tested. So to the degree that you actually have outside sources either look at what you do internally or you have contracts with people outside, or the courts have had special masters do that for you to the degree that it's legal and possible, it'd be nice to see. And then for the LAO where you have gone in and looked at these outcomes, and I know we've had really difficult time finding out what is the true rate of recidivism, I think on the adult side, and getting those numbers as accurate as possible so that they can be a good assessment tool for those generalists that are here in the legislature.
And there could be a lengthy discussion about how one defines recidivism, but what we're going to do is present the committee. I think nationally there's an effort to track information that's based on arrest, based on a return to a juvenile facility or a return to an adult facility, and we track all three because I think they reflect different types of behavior in the community. And rather than pick one, we'll provide that range to the committee and share the outcomes.
And you know, Bernie, this may be just to you, just intellectually sort of interesting. The probability, I know I'm giving you a lot of work, so this isn't right away, but you know, when we look at high-risk people coming into the system, and particularly minorities in areas of poverty, which are obviously disproportionately represented, what are the best practices that make sure that there's a less of a potential that they'll be reinstitutionalized, not just within the criminal justice system, but in other parts of government. And to the degree that you have that, again, while you're here, it would be wonderful to have a little discussion about having that concluded. So, for instance, on the foster care side, we've looked at statistical studies that show if you do this, the probability of them being successful absent the foster and adoption process, because obviously when they're emancipated, they go to other forms of subsidies.
I think along with that would be the effort in parole and throughout DJJ and the state locally is disproportionate minority confinement and really developing as much as possible objective tools of evaluation and programs that are culturally appropriate for the population in our care. There are a variety of things that we can put in place that really deal with the range of ethnicities within the DJJ population as well as the county population.
And I just want to add that that is a very important issue for us. And so one of the things that we are doing is we are working with the Correction Standards Authority, and they are putting together a curriculum for all of our parole agents in terms of the DMC, or the disproportionate minority contact, as well as, and we're hoping to put that at the refresher this spring. And then for all of our vendors in the fall, we want them to go through the course as well. Part of that is that we need to track our violations, and we need to get some data so that we can see, after we've implemented these initiatives, did we have any impact on that? So we are working with the communities in that area. That is a very important area for us.
Okay, I'm going to give my committee members lots of paperwork to either ignore or read. I know they'll read everything. The other thing, Ms. Rios, you mentioned the task force. Maybe you can give us some information of the makeup of the task force, what their actual, if they have a strategic plan, what's expected of them, do they have a timeline, those kind of things. You don't have to do that today, but maybe when
Absolutely.
You come back.
Yeah, we will be happy to give you that. We have been working on a strategic plan, a 5-year plan for the committee, and with goals, and we will give you a list of our members.
And one last thing, we talked about this a little yesterday, just the relationship between you and county probation on the juvenile side. So we talked about county probation is heavy on juvenile and light on adult. You are supervising a smaller and smaller group of people, and just your explanation yesterday, but maybe we'll have further discussion about this when you come back, the cost of you doing that more intensive, because you're going, I assume you're seeing a smaller group of people, particularly the very high risk to the public folks that are on parole, and your arguments about why you're best suited to do that, I'd just sort of like to flesh that out a little bit further. Particularly just the cost of it is that you're seeing people across county lines, in your interaction with county probation.
Absolutely.
And again, any LAO can feel free to jump in here anyways as we come back. Any comments to close on this item before we go to the next? All right, I feel like, you set, Senator Negrete McLeod? I feel like we've already started this. David, would you like to start this? So we're going to the reform proposals. And at the end of this, then we'll ask if there's any public comment when we finish with DJJ. LAO, do you want to start? We'll go back to our traditional routine.
Sure. So we have a handout prepared for you right now. And if you turn to the first page in your handout, you will see a overview of the Division of Juvenile Facilities, a background on who's there, how many wards are there, and the number of facilities. If you turn to the second page in your handout, we have an overview of the governor's proposed budget for DJF. So the governor's budget for 2010-11 proposes $403 million to operate DJF, including $390 million from the general fund. This amount is roughly $50 million, or 11% below the proposed revised level of current year funding. The governor does have several different population reduction proposals. Taken together, the proposals as originally proposed would have created $48 million in savings, according to the Department of Finance and DJF. The three proposals they have are limiting jurisdiction to age 21. Currently, wards can be placed in a DJF facility up to age 25. The governor proposes statutory changes to limit the age of jurisdiction to 21 for all wards committed to DJF after June 30th, 2010. We note that the original proposal would have released wards who were younger than 25. However, the administration has changed its proposal so that this would only apply on a prospective basis. That would obviously reduce the level of savings possible from that action. In addition, the governor proposes transferring eligible wards to adult prison. Under current law, certain wards in DJF are eligible for transfer to adult prison when they turn 18. However, there are some wards in DJF facilities that while they're eligible, they were not transferred. In addition, the governor proposes eliminating or modifying the use of time ads. The Juvenile Parole Board assigns each ward an initial parole consideration date, and currently DJF staff can delay the parole consideration date for disciplinary reasons, such as bad behavior, and the governor would propose eliminating this practice. In addition, the legislature took action as part of the special session to score $48 million in savings, though it did not approve the specific proposals to come to that amount. And also, obviously, that $48 million in savings is pending the governor's signature. If you turn to the next page in your handout, we will begin our discussion of some of the ways, some of the options available to the legislature to achieve the savings scored in the special session. We feel that there's three general ways to reduce DJF ward and parolee populations to achieve the savings identified in the special session. To begin with, the legislature could reduce admissions because for each juvenile not sent to DJF, the state saves cost on housing the juvenile as well as supervising them on parole. This legislature could also reduce the length of stay that for wards in the facilities in order to reduce costs, as well as reducing parole caseloads and return to DJF is another option the legislature has. Depending on which of the population reduction options the legislature adopted and their interactive effects, there could be significant general fund savings ranging anywhere from the tens of millions to all the way up to the hundreds of millions of dollars annually. If you turn to the next page in your handout, we'll go in a little more in depth on the options for reducing admissions to DJF. Although Chapter 175 of 2007, which is also known as SB 81, made non-serious, non-violent, non-sex juvenile offenders ineligible for commitment to DJF, the legislature could enact additional restrictions on eligibility. For example, statutory changes could be adopted to specify that only juvenile offenders with certain programmatic needs, such as wards with mental illnesses, could be committed to DJF. Alternatively, the legislature could shift full fiscal and programmatic responsibility for juvenile offenders to counties, along with a dedicated funding source, as we've recommended in the past. We note that currently less than 1% of juvenile offenders arrested each year end up being placed in DJF. If you turn to the next page in your handout, we go over some of the options the legislature has for reducing the amount of time wards serve at DJF facilities. The first option there is, of course, limiting the age of jurisdiction as the governor would propose. The next option that the legislature has is to release selected wards early from DJF facilities. For example, the legislature could reduce length of stay for offenders who are found to be of a low risk to reoffend based on a validated risk assessment. A third option that the legislature has is to expand the availability and amount of credits wards are eligible to earn towards having the earlier parole consideration date, such as by granting more credits for participating in education programs. In addition, as proposed by the governor, the legislature could transfer wards who are eligible for adult prison to adult prison when they turn 18. And finally, the legislature could also limit or eliminate, as proposed by the governor, the ability of DJF staff to delay the parole consideration date of wards for disciplinary reasons. If you turn to the final page in your handout, you'll see several different options for reducing parole caseloads and returns to DJF. To begin with, as we have recommended in the past, the legislature could shift the responsibility for juvenile parole to counties. Since each DJF parole agent is typically responsible for supervising youthful offenders residing in a territory of more than 2,800 square miles, which is about the size of the county of Santa Barbara, such a shift would facilitate closer supervision of these offenders. In addition, the legislature could consider eliminating parole for certain wards. Currently, all wards released from DGF facilities who have not reached their maximum age of jurisdiction are placed on parole supervision. The legislature could eliminate parole for certain wards, such as those deemed to be of a low risk to reoffend. In addition, the legislature could consider discharging certain parolees early. Currently, wards are placed on parole until they reach their maximum age of jurisdiction or when the Juvenile Parole Board elects to discharge them early. As a result, wards generally remain on parole for an average of roughly 2 years. The legislature could adopt statutory changes to limit parole to no more than a year after release from a DJF facility. Finally, the legislature could make certain parole violations ineligible for revocation. Currently, parolees may be returned to DGF for committing new offenses or for violating the conditions of their parole. One option to reduce state costs would be to prohibit parole to returns for certain types of less serious offenses. I'd be happy to entertain any questions that you might have now.
Good report. How much of it is original to this year and how much of it has been written before, I wonder?
There's some of these proposals are new, and that's why we phrase them as options rather than recommendations, because we haven't scored all of the proposals. The realignment proposal that we mentioned, both realigning all of DJJ and realigning the parole responsibility, is the older, some of the older recommendations, but many of the newer recommendations are recommendations we've made for the adult side, but it's haven't necessarily made on the juvenile side.
Okay. Senator, any questions of the LAO? Okay. Go to Finance, if you had any comments. All right, Department.
Well, just a couple comments. One is that our population is significantly below the projected number, about 12%, 200 less youth than we had anticipated at this time this year. So it was intended to be 1,625, and we're about 1,425 in DJJ. And I think that is due to several policy changes, but specifically reduction in time ads, and only in time ads specifically targeted for serious behavior, including assaults against other youth or assaults against staff, as well as additional time credits, and having a phase system in which positive behavior and positive programming allows youth in level A to get up to 15 days of credit. So we are reducing time ads by 50% in the last year, increasing time credits, and as a result, I think our population continues to decline. We are continuing to work with our adult counterparts to look at those adult convicted E&M cases in DJJ to develop an appropriate program for those to be transferred to adult. I would say, finally, just in terms of the DJJ population and where we are, California has the lowest commitment rate of any state in the country for who's committed to the state system. We have the most serious violent youth. 95% are in for a serious crime. So population is defined by who comes to your system and how long they stay. And I think that the final policy changes around Senate Bill 81 has really targeted a population that is not easily served, appropriately served at a county level, given their seriousness and need for intensive programs. The length of stay is an issue. The national average is roughly 9 months, and youth in DJJ stay for up to 3 years, in some cases longer. But that is really a function of the seriousness of their crime, the intensive needs that they have, mental health, substance abuse, sex behavior treatment. And we are, as part of our reform, looking for a better tool to look at their evaluation for release, their readiness for release in terms of making sure that we can feel comfortable in public safety and releasing them. But I would just caution that is there an additional cut of population that comes to DJJs is one that would, I think, put a burden on the local governments.
We talked about this a little bit yesterday, and I just wanted to explore a little bit more in terms of the cost per inmate. And forgive me, maybe I wasn't paying full attention yesterday, but it seemed a little bit counterintuitive to me, just as a simplistic state senator, that as we try to control these costs, but the cost per inmate isn't coming down at least proportionally. And what you, if I remember correctly, said, your fixed costs are still your fixed cost, which seems like if you're closing facilities, that your fixed costs should be dropping, and it's just. Explain that a little bit more.
So we are, the appropriation, the allocation for DJJ continues to decrease as population goes down, and we went from 100 living units statewide to about 52 living units. We've closed facilities, and our most recent round of layoffs and reductions with the closure of Stark and right sizing, we have reduced about 523 positions. But what happens is, because of the federal requirements of how many staff you have in a living unit, the mental health services, medical services, unfortunately, you lose the economies of scale. So while our overall agency appropriation goes down, the cost per youth as we get smaller, unfortunately, does not reduce commensurately. So it actually increases.
So even though you had 7 facilities and you have 6, maybe this is more a question, David, we have obviously the capital cost and the operational cost for that facility, at least I was led to believe that that would help, not just in terms of the total budget, but proportionally as well. And I understand the ratio standards make sense, that they still remain the same, so those costs are the same.
Well, to be clear, our average cost per ward also has declined. It was projected to be $250,000, and it's now, I think, and I don't have it in front of me, but around $220,000. So our average cost that's budgeted is declined as well. We had anticipated that it would go down even more, but with these reductions, you still need to offer as many programs. You may not need to offer the same number, but the same breadth of program as you did before. And so I think that reduced our ability to reduce the average cost per ward as much as we had anticipated, but the average cost per ward did go down as well.
Okay. And I'm sort of what I'm looking at maybe in the future is as those costs go down, but you're still providing the intense services, that the recidivism rate hopefully has some relationship to that as well. Is that, I assume that is accurate. So we will be looking at those kind of, both the interaction between those two things. And then we already discussed the realignment suggestion, so I'll leave that for the next hearing in terms of what the LAO suggested. Anything else on this item? All right, we'll go to the public. Hey, how are you, Craig?
Good morning, Mr. Chair.
And if we could keep it to around 2 minutes, we are trying to somehow miraculously wrap this up close to 35 minutes. The whole
Craig Brown for the California Correctional Peace Officers Association. A lot of information to comment on here. I just point out on your final issue about overhead and costs, that's where the problem is. That's why these costs are so high. The staff on the living units are reduced when the population's reduced. Take an example, using your own agenda. You show 161 positions in parole, and using the numbers in that, about 50 of them carry cases. So there's 160 people in the parole division. It looks like roughly 50 carry cases. It might be 55. That's a heck of a lot of overhead for 55 people. There's 2 regional parole offices. If this was CDC, our adult side, and a population of 1,700 parolees, you'd have 4 or 5 overhead positions, maybe 7. You have in this department looks like over 100 overhead positions in the parole division. Of course, it's going to cost $22,000 supervisor parolee when you spend $7,000 on the parolee and $14,000 on the people supervising him. On the shifting quickly to the populations issues. We believe the proposal to reduce the age to 21 is a policy proposal. It's hard to sort out. It is going to result in a lot of young offenders being sent to state prison for life or very long terms. Now, I guess that's a good public safety proposal if you're conservative. That's probably a bad outcome if you're liberal. On the other hand, there's people on the conservative side who say this is going to free everybody at 21 and result in shorter length of stay, and isn't that a terrible tragedy for public safety? I don't know how to sort that out. What I do know is if you do this proposal, you're going to sacrifice a lot of young people to the state prison system for very long periods of time. Given the fact that there are no budget savings, or virtually no budget savings in the budget year, we think they ought to run a policy bill, take it through policy committee, have full-blown hearings in policy committee, and flesh out and decide if it's the right public policy. The issue of time cuts and time adds, our issue is not worth time cuts that people earn. It's with time adds that people earn and don't get. Time adds are one of the mechanisms for deal with these very serious wards who misbehave. And we think it's critical for the safety of the staff involved that there be some penalty for misbehaving. And if time adds are rewarded for good behavior, we think, or time cuts for good progress, time adds should be at least one of the options available for bad behavior. Given your time frame, I'll shut up at this point.
Okay. We'll come back and ask the department to respond to some of those things.
Always hard to follow, Craig. David Steinhardt from Commonweal. I've worked very closely with this committee on all of these issues and was asked to comment by staff on the governor's proposals. First thing I want to say is I think LAO is right on trying to help you focus on the length of stay issue. California is out of whack with the rest of the country. Florida keeps its maximum security juvenile offenders in its corrections facilities for an average of 14 months. That's your big cost item at $225,000 per year. We need to do something about that, and that means we need to revisit these old, antiquated sentencing guidelines that were created in the 1990s during the violent crime years, and those drive now how long kids stay. Time adds compound that. That's probably a longer discussion than something that can happen in this budget cycle, but we should not forget about that, and LAO has made some suggestions in terms of controlling that time. As to the specific governor's proposals on dropping the age, this proposal's been around for quite a long time in the governor's Juvenile Justice Working Group in 2004 and 5. We looked at that. Prosecutors and advocates rejected it for the reason that Craig Brown just brought up. It would sacrifice a lot of kids to the adult court system. I must say, though, things have changed, and as an advocate, I've done a lot of soul searching, and what's really changed is that the violent older juvenile offenders are already going to adult court in droves. And so the impact of actually adopting this cost savings policy, and a lot of costs can be saved, is reduced. We took a close look at the data at DJJ, and we came up with about 50 young people per year that we think would now be filed on in the adult system because prosecutors can't get confinement in DJJ to age 25. That's a sacrifice, but the benefits of dropping the age are that you convert DJJ to a truly more juvenile system, and the programming can follow. In short, we could be more like Missouri and less like California. And then the cost savings are substantial, running in the range of about $50 million or so a year. Not everybody agrees with this, but it may be, and I don't know if you're agonizing over the policy or not. And you can't realize the savings in one fell swoop. But you can sort of parse the release policy for the 300 or so over 21s who remain in DJJ. And I'm just suggesting that it's a balancing act as to what the policy should ultimately be. Time adds. I've tilted with this administration on time adds for quite a long time. I've drafted some very unsuccessful bills for members of this legislature. Until just the last year, time adds were so out of control that they were responsible for about 40% of all time spent in DJJ, running over $100 million a year in costs, time adds alone. A lot of strides have been made. Bernie has referenced those. Time adds have come down. But the real question is, do we need time adds at all? I'm puzzled by the governor's proposal in that I don't know whether he means eliminate time adds or not. or whether we're just kind of going to go ahead in a fuzzy way and say, well, we're going to try to do the best we can. But I really think that it's time to pull the plug on time ads. The disciplinary time ads, do we really need them to control discipline in the institution? Piling onto the longest sentences in the nation, there are plenty of other sanctions to apply within DJJ for violations in the institutions. Withdrawal of credits could be one, different withdrawals of privileges and the like. And the other area that nobody talks much about is program time ads, TTA time ads that are added by staff. Wards are mystified by this process. Go do anger management again. The appeals process to the board is a mess. So, I mean, I just don't think there's any evidence that these time ads produce greater public safety when these kids get out. And if you don't put some boundaries on time ads legislatively or in this budget process, we will just continue to go on the trust model. Yes, DJJ is doing better, but you're not going to get the savings guaranteed in any way. Then I wanted to briefly talk about something that I talked with staff with. I think in terms of just realizing cost targets, you want to look at the parole violators who are coming back. We're getting more parole violators coming back to DJJ, almost 500 per year, than original commitments from the juvenile courts, which are around 300 per year. Under LH, they can't stay longer than 12 months, but they are staying 10 months each. What is the magic in keeping a technical parole violator back in DJJ at $225,000 per year for 10 months, and then releasing him perhaps with no more available confinement time and little opportunity on parole? I think here's a place where you can make some moves. And for example, you could cap the time on a first return for a technical violation at 3 months. That has dollar savings. And the other opportunity you would have is just to ban returns of technical violators and make them county cases. And this is kind of what we did with SB 81. When there was a technical violation for a non-707, we turned it over to county. We held a new disposition hearing for those kids, but we had to pay the counties to take over the parole in that case. In any event, this is there's a lot of money to be saved by taking a look at the volume and the length of stay of these technical violators coming back. And then finally, my final comment is as to the proposal to turf the over 18 kids to CDC immediately upon arriving at age 18. I think this is a bad idea for those young people who can complete their sentence at DJJ by age 21. I helped to write the law that carved out this exception 15 years ago, and the question, the policy issue still remains. What sense does it make to invest all of those resources in a rehabilitative setting, then pull the plug for 1 or 2 years of final sentence and shove the young person into the prison environment? I know there's money involved. A lot of these kids, by the way, according to DJJ, are in the camp programs, which are very good programs. But I would urge you to hold the horses on that one piece, or to come up with some criteria, keep the policy of letting those who could finish their sentence prior to age 21, letting them stay under some criteria in DJJ, at least part that population, rather than throw them all out.
Before you go, David, all of this, I assume you can submit for the record so we can read your words of wisdom.
Yeah, I had a lot. Yeah, I got it. You can have it. Okay.
In Florida, the shorter stays, is the result in greater public safety, less public safety?
They track recidivism, and, you know, we've had a discussion about recidivism. We're a little tied up in some very lousy recidivism measures for DJJ releases. We're measuring returns and revocations. I think Florida measures new violations, commitments, new crimes within 1 year of release, and they're running about 2/3 success rate, as I recall. The good news is they actually publish the data. They actually publish the data. You can go online and look by level of security, age, offense, and recidivism rates, and we're just way behind that in California.
Okay. The last thing was Washington State Institute of Public Policy. Are you familiar with them?
Yeah.
It's just some of the stuff that staff's brought to me is it at least on the surface is sort of what in my mind I'm looking for, where you've got cost benefit on all of these things. Bernie, I don't want to get too off track here, but you're moving your body forward. So for either of you, I mean, some of the stuff you can get off their website, it just seems very detailed, very objective, and actually measures the cost benefit in round dollars. Do you have any comment about that?
Well, just a quick comment, and they do great work, great evaluations. The only concern is that in the juvenile side, most of the Institute for Public Policy's work has been around programs in the community, and very few that are in residential programs. So it's a bit uncharted waters of looking at what happens in confinement and then future recidivism. Most of those are for already a population that's in the community. But there are components of each of those cognitive behavioral interventions and other programs that we are using in our residential facilities. I just don't think there's the same kind of evidence-based data that reflects outcomes the same as the community programs.
Well, you know, this just all of a sudden had a flash of, in Contra Costa County, we did what a lot of counties did. We had a continuum of care around at-risk kids, and it was really helpful, and I don't know how accurate it was, but to the degree you could become more accurate. So you've identified the at-risk population before they've been adjudicated, and you sort of look at best practices over the course of the widget's lifetime, for lack of a better, and are those good programs?
Most of those would be reflected in a wraparound model, and I think that I maybe didn't articulate very well originally, but really the reforms we are looking at DJJ are a continuum of care, so that parole becomes an aftercare model.
Okay. All right. Thanks, David.
Okay. Thank you.
Thank you. Next. And again, I'll try to restrain myself here, and if you could try to articulate your thoughts quickly.
Attempt to be brief. Good afternoon, I guess. Mr. Chair, members, Elizabeth Howard Espinosa on behalf of the California State Association of Counties. Lots of moving parts here, and I sort of want to take a broad context. We are, from the county perspective, acutely aware of the challenges that the state faces in the correction systems. There are many interactive parts, interrelated parts. Corrections is a closed system on both the juvenile and the adult level, so decisions that you make will affect us and so forth, and we're certainly understand that. Just in terms of context on the juvenile justice side, all of the programs for which the state has funded, and we're most appreciative that have allowed us to do very good things at the local level and keep kids out of DJJ, which in part is attributed. Certainly there have been other policy decisions that the legislature has made, but that does contribute to the low population at the Division of Juvenile Justice presently. Most of those programs, with the exception of the funds we get for SB 81, are now funded through the VLF. I only make that comment because that has been a declining revenue, so declining VLF on top of declining local revenues, cuts that have resulted from our general economic decline, and state budget actions have resulted in unfortunately, decimation of many programs locally. So that's the context in which we're living. And I think we have to be aware of that as we move forward and talk about who should do what, where, and when. Caseloads are high. Our social safety network, folks who would be providing mental health, alcohol, and drug services, local public safety departments have taken cuts. So additional responsibilities on top of a somewhat shaky foundation may not produce better outcomes. Just thought I would make the point. CSAC has a very broad policy that there is an important role for the state in this continuum of services, that there now, because of SB 81 and other changes that have happened over time, DJJ has the most difficult, most in need, most violent youthful offenders. We don't think broadly statewide that counties really are equipped to take charge of those kids locally. So I wanted to make sure that was clear. I'm not sure that you would find broad support for an entire realignment of juvenile justice, but also we do understand the interconnected nature, and we are happy to participate in the discussions as they move forward.
Thank you.
Thank you.
Always nice to hear from CSAC. Well, almost always.
Hello, Mr. Chair.
Hi.
Senator Grady McLeod and staff. Pam Gibbs for the Los Angeles County Office of Education. I want to echo the comments made by the previous speaker. We, too, are heavily impacted by the shift of youth to the local levels. We are particularly interested in providing the same kinds of services that DJJ once provided to the youth that were once housed there. In particular, of course, I'm speaking of our education programs. As you know, we have received decimating cuts over the years. We've lost flexibility, or we now have flexibility of funds, but we have lost a great deal of money in revenue limit cuts over the last several years. So much so that we have to let go of teachers, we have to close down some of our programs. At the same time, we're being asked by advocates and through lawsuits to provide the same kinds of programs that you find at DJJ. We do not have the funding base to do that, and so we've asked for your help in realizing some alignment of the funds as well. To the point of the violent youth, and I don't want to contradict Elizabeth, but we are concerned that there's a misperception that the kids that are housed at DJJ or at the local levels are, for lack of a better word, bubblegum chewers, and that's not the case. We do house adult charged youth who, once the determination is made, those youth go to adult prison. They do not go to DJJ. These are the worst of the worst. We do have some of those youth there. We also receive youth in pre-adjudication, whether they're at the halls just before they go to camps. So I don't think the charge that the child has received is the determination of how violent the youth is. We have lockdowns on numerous occasions, and then we don't have fixed costs that DJJ has just reported that they need to sustain. If there's a lockdown and we're funded on an ADA basis, we have teachers sitting there with an empty classroom, no bottoms in seats, and therefore no funding. So we're experiencing deficits to a great degree. We also are interested in offering the same breadth of services that DJJ provides, as I've stated before, and with that, DJJ has recommended in January of 2009, LAO has recommended in January of 2009 that some of the Prop 98 savings that were achieved in the shift go to the county levels. And so we ask you to make that consideration. Thank you very much.
Appreciate it.
Afternoon, I'm Sumaya Waheed. I'm with Books Not Bars, campaign of the Ella Baker Center for Human Rights. We're based in Oakland, and we represent families of youth who have been incarcerated either at the state level or at the local level. And there's about 1,000 members in our network, and we've been campaigning for years to replace the DJJ with effective local and or regional alternatives. And I've submitted a letter to the committee that lays out our position on the population reduction proposals, and also reiterates what we've been arguing, which is that California can no longer afford to spend $225,000 per year per youth on a failing system. Instead, we can focus our energy and resources on a smooth transition to local care, funding counties so that they can take these youth, giving them oversight and technical assistance and leadership to really prepare them for reabsorbing this population. And a key to this proposal is addressing what others have identified, which is the uptick in youth being charged as adults and sent to adult prison. As David Steinhardt said, it has already started to happen, and so it needs to be addressed regardless. We've proposed a fee based on the sliding scale that counties paid for youth being sent to DJJ, a similar but flat fee for each youth sent to adult prison. Because the policy is basically that youth who get sent to adult prison face danger and violence and worse outcomes when they come back. So as a state, we should be looking at that, and we should be looking at ways to deter that. And there are other ways to control that are described briefly in my letter, but in the interest of time, I won't go over them. But, you know, in some, we're in a painful moment in our state, our budget crisis. So we really do need to take the time to redirect this funding towards a better system that will give us better outcomes at the community level for youth and for our pocketbooks. Thank you.
Thank you. Thank you for the brevity. But we have your letter. Yes, next.
Hello, my name is Pam Handel, and I am a teacher in DJJ. I'm a special education teacher. I've come to a few of these committee meetings, and I hope that I don't repeat myself, but I did want to say that maybe of all the people in the room, barring, of course, Mr. Warner, I might be the closest to the kids that you're talking about today. I kind of wanted to address the 18 and over concept of moving the students, and I call them students, young people, from our DJJ facilities into the adult facilities, or even the concept of 21 and over. 18 and even 21 is not necessarily a magic age. I can understand why people might have chosen that one, looking at other states that have possibly a different type of population that we have. I've worked for the department for almost 20 years. When I worked for the department, we mostly had runaways, car thieves, that type of thing. We now have young people, most of my students at least are, young people with a lot of mental health issues, a lot of difficulty in dealing with just daily life, let alone trying to figure out what they're going to do when they get out. A lot of students that have problems learning, whether they're truly special education students, and I am a special education teacher, or just the fact that they have stopped going to school so long ago that they don't even know how to go to school. 18 may seem like 18 to a lot of you. If anyone has an 18-year-old, you know that an 18-year-old might be graduating from high school and getting ready to go to college. But an 18-year-old to me, from one of my students, might look more like one of your 14 or 15-year-olds. Still struggling, trying to figure out what they want to do, still struggling with maybe about 60 to 90 credits, still struggling to try to figure out how to work in a world and be successful, in a world that has not really been a good role model for them. We become role models, we reparent them. 18 is not the line in the sand that I would pick. But also knowing that special education, federal laws, and the money that comes along with that says that a lot of that funding is about keeping those children until they are in the end of their school year, of their 22nd year, if we can get them as far along as possible. We have ELL issues, we have special ed issues, we have the mental health issues. There's a lot of things that we do that show that we are the experts with the kids. I'd really like for you to consider watching what's happening with this concept of moving kids out early based strictly on a number to try to save money. If we can keep them as long as possible, do as much as we can for them, I think that they will be more successful. I have a student that has recently contacted back to our school. He has to contact the school. He doesn't know how to reach us at home or anything. And he's asked if some of us could come to his wedding. He is getting married. He has a job. He has a baby on the way. A few years ago, he didn't have a diploma. He didn't have job skills. And he had some suicidal moments. We walked him through all of that, and he's a much more successful person. That's the type of stories that we have over and over again. We'd like for you to consider that as you consider these moves and these potential things. The age of the kids is not necessarily the same as a student that you might see if you went over here to McClatchy or Johnson or something and talked to an 18-year-old.
Thank you. Thanks for your testimony. Thanks for coming. Last speaker on this item.
Good afternoon. Karen Pank on behalf of the California Probation Officers, Chief Probation Officers of California, and I just wanted to briefly state, obviously it's already been testified to, but we do have some concern about the 21 to 25 age jurisdiction, as well as any further realignment. And if I could just point to, we've done recent realignment with the SB 81 and are attempting to still try to adjust to some of that. We've got some very large parole caseloads in many of our counties, some as high as 90 to 1 in Fresno. We've got about a 55 to 1 in Contra Costa. So, we just need to look at the entire system before, maybe discussing some of those items that have been brought up here today. So we look forward to working on this. We know it's a large problem, but we have a lot of those similar problems in the local arena at the moment. So thank you for your time.
Appreciate it. I do want to wrap this up because we have the next item is a vote item, and I want to get that before Senator Negretti McLeod has to leave. Any comments on this, Senator, on this item? Follow up to some of the issues that Mr. Brown brought up. Just the issue of the time ads, and David brought up as well. I guess we've heard testimony in LAO, if you could, not now, but when we come back, the idea of the safety of the employees and the effectiveness of time ads in addition to the savings and the change. So it's good that you're dropping them. We want to make sure that there still are necessary tools that your employees have to make sure their own safety. Let's see, administration would be particularly helpful because we're going to have this discussion on both sides, the adult side and the juvenile side. What is the proper percentage? To the degree, again, I know that we can't do cookie cutter, but what's the right amount of administration? And certainly Mr. Brown's comments, if that were true, 160 positions and 53 points of service, and I know you're eager to answer that. You are in some way, but you can do it in the future. But so as just for when you come back, and we can have some discussions about this offline as well. And reduction in sentences and also the impact, obviously, we had on county farms and county programs, so we have a little more discussion and a little more help from the LAOs, and I apologize for sort of rushing through this, but we do have the advantage of being at the beginning of the process here. So I appreciate you coming, and I didn't want to mean that in any of the comments I made, Bernie, that I was anxious for you to leave. Just thought,
I did cross my mind.
Well, don't take it personally. They say that to us in the term-limited world all the time. Anyways, thank you. We look forward to further discussion. Also, just on the reentry part, it's my hope, in talking to the pro tem, that we have a hearing just about reentry, and we'll have a little bit on probation and on the adult side, just to make sure that we're doing everything we can within the constraints of budget to make sure the public is as safe as possible, because obviously I think all of us are getting a lot of feedback when we go home from public safety people about their concerns. So at a future date, we'll have that discussion, and maybe we'll do it with the policy committee. Thank you.
Thank you.
All right. Next item, Sex Offender Management Board, and we do have a recommendation to approve these, so we will try to do this quickly again. And we'll hear first from the LAO.
Paul Goliziski with the Legislative Analyst's Office. The governor's budget requests $561,000 and 3.5 positions to staff the Sex Offender Management Board, as well as the committee that oversees the state-authorized risk assessment tools for sex offenders, or SRATSO. The Sex Offender Management Board was set to expire this year, but the legislature removed that sunset date, so this would just continue funding and staffing for the board. We have no concerns with this proposal.
Finance, any comments?
Justin Howard, Department of Finance. We support the staff recommendation.
David, do you have any?
Just that we are really supportive of the Sex Offender Management Board and the work that they've done. Obviously, they appeared before the combined committees a couple of weeks ago, and you saw some of the outcomes of their report. And I think it's important that those discussions continue, and we're really supportive of the continuation.
Thank you. I think we're all on the same page. They do good work. Senator Negretti McLeod, any comments? Or we wish that would happen to other people. All right. So the recommendation is to approve. Unless I hear any member of the committee dissent, then that's approved, the recommendation. Thank you for the good work, and thanks for the good work for both the administration, the department, and the LAO's evaluation. Any public comment under this item? All right. We will move to mental health programs. So we're moving to issue number 4. We have no other vote, so you're free to go. I'd be happy to give you cliff notes or provide you with copies of the testimony. I'm sorry, my estimate that would be done by now is inaccurate. By the time I'm done, hopefully in 7 years, I'll get this down. Thank you, Senator. LAO? So the rest of the items are all to hold over and to give direction. Yep, and if you have anything you want to add after, feel free, and we'll communicate it. Okay, LAO.
Thank you, Mr.
Senator.
Chair. Aaron Edwards, Legislative Analyst's Office. The department is requesting an additional 362 positions and funding that will eventually total $77 million annually after full implementation in 5 years. The positions are in addition to 245 positions that were approved in the 2008-9 budget package but not funded, for a total of 607 mental health care positions. For 2010-11, the governor's budget proposes $9.8 million in funding for 73 of those 607 positions. The request is based on a new staffing analysis conducted by the department. They conducted this new staffing analysis after making a determination that our current staffing methodology is unreliable. The current staffing methodology was based on a workload analysis ordered by the court, the Coleman Court, which oversees mental health care, in 2006, and subsequently the budget authorized 404 positions based on that workload analysis. We, at this time, would recommend that the legislature reject this governor's proposal, and we do not feel that the CDCRs at this time made a strong enough case to justify moving to a new staffing methodology, especially at a time when the cost for mental health care has increased significantly in the past few years. In addition, we would recommend that the legislature require the department to come back in subsequent hearings and report on the number of positions that would be needed to fulfill the current staffing methodology. That concludes our comments. I'd be happy to field any questions you have.
Thank you. Finance, any comments?
We would just note that we never actually implemented the SAM. We never got funding positions for it. We made adjustments based on general ratios from the SAM. We never actually used their tool because it was unreliable in their findings. And we weren't confident that we could reproduce the same allocations every time. The department has more concerns with the SAM that they'll get into. So pass it on to the department.
Okay, I'll pick on them, not you. Just check. All right, welcome.
Thank you very much. I want to just do a bit of an introduction to this whole issue so that there's some context around what we're trying to do. The staffing plan is quite important to us. I did this same kind of thing with the mental health lawsuit in Ohio, and from my experience in this, there are three major pieces to the Coleman lawsuit, which have to do with having the right proper beds, treatment space, staffing, and then the issue is access to all that to make it work. We have not been very successful in any of the access issues simply because we don't have the beds or the staffing that we need to do the job. The concern that we have been having is that we were ordered, as has been pointed out, to do this plan in 2006. We did come up with a SAM. Since that time, we really, not a whole lot was done over the 2 years in that time after the SAM was completed for a host of reasons, which I can get into. But then the court issued a new order in the summer saying that we will come up with a final plan on staffing, and this was in June of 2009. So we were tasked with having to come up with something that would be acceptable to the court and that we felt would get the job done. So what we did was, going back, I think, to the original issue around the SAM, it was wrought with a number of problems. But I think the bottom line is that we contracted with a group, then we received almost $750,000 from the legislature to contract with this group a couple years ago in order to develop the SAM. They came back with a model with a model that had a number of questions associated with it. So they asked us to verify their assumptions and a whole lot of other things. We had a very short time frame in order to do that. And the contract was ending, and so that work was not completed. In the meantime, the staff were diverted off into other kinds of activities. And then there was a realization that we would have to lay off, apparently, hundreds of psychologists in order to make the plan work. And that goes to the whole issue of why this plan was not implemented. So really, essentially, I think we ended up just not doing much with it because it was wrought with so many problems, nobody knew quite how to get out of it. So then, when I was faced with this, I have a court order now in June, I have to produce a plan by August. What I proceeded to do at that point then is to look at, and prior to that actually, when we knew this order was coming, we started to look at what can we do with the SAM. I arrived in February. I find out this is a potential problem in March. I started working with our staff around what the problems were going to be. We really tried to salvage the SAM. This was, we looked at first the mechanics of it, which were very problematic. We looked at ways we could fix that. Then we discovered there were so many problems with the assumptions. At that point, what I did was I had to make a decision about, am I going to try to fix something that my staff is telling me it would take till December of 2009 to fix? Or am I going to do something that has worked for me in the past, which was the reason I adopted the staffing ratios is because I had done this in Ohio. We developed it. We didn't pay anything to develop it, and nor did we pay anything to develop this one in term other than staff time and working 24 hours a day on it. And so what we did in Ohio lasted through the entire decree that we had in Ohio, so I knew it worked. Jeff Metzner, who is one of our Coleman monitors, was also a monitor for me in Ohio. He was a part of our staffing there. He was also in charge of the group that the monitors assigned to work with us on the staffing models, so I knew this was going to be an acceptable staffing plan for the monitors. So we set about correcting these things and working with, we brought everybody in up front on the process and really tried to come up with a plan that would meet everyone's needs, including plaintiffs' attorneys. The plaintiffs have not objected to our plan. The special master had significant concerns with the staffing analysis model. We do have, I think, the letter originally that the special master had sent, may have been some misinterpretation about his support for that model. He has subsequently submitted a letter approving our plan and outlining the problems with the staffing analysis model that was originally developed, which I think is fairly clear about their lack of support for that model. So as a result, where we are, I think at this point, is with a plan that we have broad support for. We are not getting any objections, and the most important thing from my perspective is that if we do not get this plan approved by the legislature, my fear is that the court will order it, and they may order not only hire 73 positions, but do it faster, so hire 200, and in addition, they may also add in nursing that we did not put into our proposal. There's around 340 nurses that were developed as part of the proposal that we worked with the receiver's office on. The receiver and we and everyone agreed that those numbers were not validated yet and that we needed to take more time to be sure that we needed those numbers. They have been in the process and have worked with finance over the last year to baseline all their nursing positions. They now are going to the next step around the mental health position, nursing positions in particular, to make sure that those are accurate numbers. So that is not contained in our proposal. So we believe that it's prudent to move forward with this staffing plan, given that I think we are clear about the things that we have proposed that we know that we need to get the job done. And also, we're going back then and working on the nursing. And we believe then we get in front of the court. We do not, in my view, when you have us here and the court here, what happens when we make decisions and take control of our system, we move forward and they start to move back. If we don't move forward, the court keeps moving forward and adding court orders to what we do, and now they're in the lead. My greatest concern is that we are in charge of our own system, that we make decisions about what we need to do as a state of California, as opposed to the courts making that decision for us. And I think that the history of Coleman in 15 years has proved that when we don't take action that we know we need to take, the court does take action. We have at least 150 court orders, which has defined the suit. We lost the suit, which is very different than many of our other cases. Because we lost it, the court has made decisions on our behalf. We have to get past that, and we've worked really hard, and I think that you'll see the beds that we have come to an agreement on is a really key thing for us, as well as the staffing. If I get those two things, I can make the rest of it work. In Ohio, I was given those things right up front, and I made it work, and we had completed 90% of the requirements of our consent decree in 3 years. It can be done, but we got to do it ourselves and not wait for the court.
Can you do it in a year?
I would love to, but I don't think that'll work.
Okay. Well, it is difficult, and you and I have talked about this a little bit, and it's welcome to California.
Thank you.
Did you have buyer's remorse in March when?
Not at all. It was very exciting because we have real problems to solve, and I think we can do it.
That's the right attitude. I think that this is the recommendation again, is to hold this open. But we have to have some serious discussions, I think. And going back to the discussion, if you were in the audience when the Department of Justice was here, just the probability from a legal standpoint, and you're a lovely person and have a great resume, and I have great confidence, but I think the legislature knows that the investment we're making at long last will finally bring us to a closure, hopefully. In addition to providing the services, that is the spirit of the lawsuit, so that clients will get the services they need, and we'll start to see some other cost savings in other places. So we would like more of a discussion about the LAO's suggestion. We're going to have to, as we go up the chain here to the full budget committee, and as I have discussions with the leadership, we are going to have to justify this investment as well. And there might be some people in this building who think it's better just to wait to have the court tell us to do it. So you're sort of the delta between what you're suggesting that you anticipate we may well have to pay is a discussion I'd like to have with our legal team as well in terms of the probability. I don't want to have a court decide. I'd like to get in front of it, as you suggest. But it is a struggle right now, as we talked about yesterday, that we've got to comply and anticipate what the court's going to tell us at the same time that we have these pressures on the state's general fund. But if we just chase that, there is a self-fulfilling prophecy of that will continue to be ordered by the court, and last and probably most importantly, clients won't get the services they need, and we'll start to see the outcomes we want.
Absolutely.
Let me ask you a question about current vacancies and potential savings, and maybe this is David. How many vacancies do we have now? Have you booked those? And are there any additional savings there potentially? And if you don't have those answers now, we can take them when you come back.
I don't have the specific answer as to what we have now. Sharon, do you?
In terms of vacancies?
Yeah.
Yes. I do have, as of January 2010, I think where we get into confusion is that we have vacancies that are based on civil service positions, but we backfill with registry where we need to in order to get up to the levels we need to. So I think that creates confusion. Our vacancy rate for psychologists without any registry, this is all civil service, is around 10%. With registry, it's 2%. For psychiatrists without registry, it's 29%. With registry, it's 11%. And for clinical social workers, it's 11%. Without registry, and with registry, it's 8%. And I need to note on the social workers, that's much higher than we would normally see because we currently have a freeze on social workers, given that we're going through a layoff process and all with social work. So I think that, and our concern here is that we make sure that we continue to try to hire as many civil service as we can. Mm-hmm. We would not want to say, let's just go hire registry. We want civil service, so we need to be able to have those savings available to hire registry when we can't fill them.
And I think some of this question may be driven by the LAO's recommendation, and the LAO's recommendation and their report was driven off some faulty information the department provided to the LAO that implied that we had about $100 million in salary savings in 2008-9. In re-examining that, There were some errors on the spreadsheet, as well as it did not take into account several factors, including the unbudgeted normal salary savings that's taken on positions. In the end, it appears that the actual salary savings rate for 2008-9 was closer to $50 million. The registry costs about 46, but we also have costs that we incurred through the receiver for Suicide Watch, which exceed $10 million, and there's also overtime costs. There isn't any available savings in the mental health program as it currently exists to fund additional activities just due to those factors. So I wanted to clear that up. And that, once again, that was a report that, based on a spreadsheet that the department provided, that was inaccurate.
Okay. Never give inaccurate information to the LAO. I'd like to just a little bit on mental health care costs. So the use of lower costs, for instance, prescriptions. Do you do generics, things like that? Are we pursuing those kind of things to reduce costs?
Absolutely. The receiver's office has responsibility around pharmacy, right, for all of mental health, dental, and for medical. And what they have implemented is a formulary and a number of different measures to try to reduce pharmacy costs. And I can get you the specific information on what the savings have been because of those implementations. I don't have that off the top of my head.
Okay, I would appreciate that. So we'll continue this discussion in trying to balance your anticipation of legal success and financial success versus our immediate fiscal concerns. Thank you.
Thank you.
Any public comment on this item? Seeing no one? All right. That'll take us to item number 5. Thank you. This is a Coleman short-term and intermediate custody. And this is to hold open as well. Everybody's staying at their position. Any comments from LAO?
The administration is requesting $6.7 million annually and 73 limited term positions to provide custody support for 13 short and intermediate mental health housing units.
Finance? Anything?
We support this proposal.
Okay. Anything from the department? David?
The basis for this proposal is what was previously known as the prevalence and mix adjustment, which was prior to the SAM, the way that mental health staffing was adjusted within the department. And that model included staffing for custody services. That model has not been used since, I think, 2006. And we have 4 years of increasing mental health needs that haven't been, the custody needs haven't been addressed. Just to be clear, the courts are very concerned about, as Ms. Ongst pointed out, the access to care, which includes the custody needs to provide that access. Without those positions, it's very difficult for the department to do that without the use of unbudgeted overtime, which is something that the department is really trying to get a handle on to avoid the use. And these positions would have normally been approved through the budget process, through the population process in previous years, but once again, we discontinued the use of the prevalence and mix adjustment.
Okay. Well, the idea is to hold it open, to continue to work with the committee staff and the LAO, because again, the cost is a concern. So, any public comment on this particular item? All right. Thank you. Correctional Treatment Center at San Quentin staffing is issue number 6. LAO?
The governor requests an additional 12 positions and $762,000 for support of the mental health crisis bed unit at San Quentin Prison in order to meet Title 22 and Title 24 licensing and programming requirements.
Finance?
Michael Mel, Department of Finance. We would just note that the department received 40 positions last year for the San Quentin Finance letter. I think the agenda states 106 positions.
Okay. Department, have any comments? You'd like the positions?
These positions really are the ancillary kind of support to the CTC beds at San Quentin. Those positions, while not necessarily all clinical, really are necessary for us to operate those beds under the title requirements. And there's also some operational needs that are addressed, such as scheduling and other issues that otherwise prevent really the optimal usage of those beds.
Well, I guess this is sort of the military thing of how many support services do you need when you come back, if you have any sort of statistical or formulas that drive this in mental health, that'd be helpful.
And most of these positions, except for a small number, I think 3 or 4, are driven by the licensure requirements. Okay. Even though there's support, there's still licensure requirements as far as support for pharmacy and other aspects as well.
So maybe I'm referring to 3 positions: a store supervisor and 2 office technicians. So I know we're down to Correct. The micro, but any degree you can give us information, that'd be helpful.
Absolutely, we'll be happy to provide that.
Okay. All right. Any public comment under item number 6? Seeing no one, we'll go to 7, which this is the SCAAP. Are we going to get more money from the federal government? LAO, do you have any ideas? Do you know anyone in the administration?
Well, under the State Criminal Alien Assistance Program, or SCAP, the federal government provides reimbursements for state and local governments to cover the costs associated with incarcerating undocumented immigrants. For 2009-10, Congress appropriated $330 million in total for the entire country, and the state of California is expected to receive about $96 million. The president's budget for 10-11 proposes $330 million. That hasn't been finalized by Congress yet. And the administration is assuming that we will receive $970 million. We think that this level of savings that the administration is assuming is very unrealistic.
Department of Finance, do you have a check from the administration?
Justin Howard, Department of Finance, working on that. While we do note that it's going to be a challenge to receive this, we do support this action at this time. Historically, California has been underfunded from the federal government in the receipt of our fair share of resources. Especially, this is one of the major areas where we have historically not received our fair share. We assume that, from the beginning, that the $330 million being proposed in the current president's budget is a good starting point for the administration to work from. Historically, the president's budgets have proposed $0 in funding for this particular area. So we view this as a recognition on behalf of the federal government that they finally realize that maybe they do have a role to play here and that they are responsible for paying some fair share of their costs of not protecting the borders and keeping out undocumented felons.
Big improvement over the previous administration, Mr.
It is a big improvement, but going back 10 years, back to the Clinton administration, most of them have never proposed funding in this area. So we're in a much better starting point, starting from $330 million than from $0 million. Back in the days, California historically received much more funding, upwards. The entire state, including locals, would receive anywhere up to $250 million. So any increase that we can get will be a benefit to the state.
Okay. Well, there's always hope and change, so we can hope, but most realistically, we're probably not going to get this amount. So I'm just speaking from my perspective, that reality, what we should actually carry it in the budget, and what the consequences of us not carrying it and expecting more, I think, is a real concern. But we'll hold that open and hope for the best. I don't suppose the department wants to make any editorial comment. Well said. Public comment. Mr. Moore.
David Warren on behalf of Taxpayers for Improving Public Safety. I think that the projection of $880 million, I think we have a better chance of seeing Elvis entertaining in the Senate chambers. What is frustrating for myself is, as a chaplain inside, I constantly meet inmates who would voluntarily repatriate to their country of origin and completely remove themselves from the country not being paroled, recognizing that they will have to serve a term in their country of origin. There's simply no reason why the Department of Corrections and the Board of Parole Hearings cannot transfer these individuals into federal custody pending transfer to their country of origin. Since there's approximately 27,000 such foreign nationals in our state prison system, even if 1/2 of them volunteer for repatriation, we would save an extraordinary amount of money, and we wouldn't be worried about what we're going to get from the federal government. Right now, getting a permission for a transfer is like trying to get a heart transplant for an inmate. It's taken me 3 years to get one Israeli national approved, and I'm leaving, if health providing, next week I'm leaving for Israel to make sure that the transfer is completed, and that one man will hopefully be the first of removing the rest of the Israeli nationals back to Israel. This shouldn't be the way it is done. It should be done so that people can come forward and be transferred into federal custody to a tremendous savings to the state of California. Thank you.
Thank you. Anyone else? Forgive my ignorance, but have we tried such a thing before? Do we try things?
There is a process whereby inmates can request transfer to their country of origin. Obviously, the vast majority of the inmates that are foreign nationals in our prisons are from Mexico. I think foreign national treaties with Mexico limit the number of transfers to around 200 per year, and obviously that would have a very tiny impact on our population. And the receiving country would have to agree to receive them and house them for that time, which obviously would be a cost they'd have to incur. I think we've had numerous discussions about this several years ago, and the department does try to identify inmates that are interested and transfer, but that also has to go through the U.S. DOJ and then through those various countries for those requests, and it can be a lengthy and very burdensome process.
So we can do 200 requests for transfers?
There's 200 total that are allowed to transfer, I believe, for the entire country.
Oh. How many do we have in California?
Mr. Lewis is correct in that the receiving government or the receiving country would have to first accept receipt of this inmate and allow them to serve their term in that country, which sometimes can be at issue how long they're going to serve in the other country. Having said that, the Board of Parole Hearings does issue reports. I believe it's twice a year on the number of people who have participated in this federal program that allows for this transfer to their country, and I can get you a copy of that report. I didn't bring it with me today.
Do we know how many we successfully transfer in the state of California?
It's in the report. It's not a lot. I believe it's like around 20.
Out of how many?
A year.
Out of 23,000 that are foreign-born.
Correct.
Wow. Well, I know Senator Cheney has been involved in this, and actually she's involved with some kind of discussion.
Right, and these countries have to have treaties with the U.S. to accept them, and not every country does have one of those treaties. So.
Okay. Thanks. Okay. Any other public comment under this? Then we will go to our last item. Issue 8 is a population request. And once again, we are holding this issue open for the May revision, but we'll start with the LAO.
CDCR issues a population request which takes into account changes in the inmate and parolee populations and makes adjustments for that, and also in terms of how they plan to house them. In terms of the table provided in the agenda on the population request, just a couple of comments that we have. For the adult population caseload projections, for the first 6 months of 2009-10, we calculated that the average daily prison population was about 300 inmates lower than the department had assumed, which would translate into about $7 million in savings. The department will adjust that at May revise, but so far the inmate population is trending a little lower. In addition, we discovered a technical error regarding the adult prison population caseload budget for 2010-11. That would result in additional $14.4 million in savings. And again, the department will adjust this at May revise. Going through some of the specific issues that are listed on the agenda, with regards to the legislative population reforms, this is taking into account all of the actions taken during the 2009-10 budget to reduce the inmate population, some of which did not materialize for various reasons. The department will make adjustments at the May revision. We do have a couple of concerns so far. For example, the proposal to use alternative sanctions to divert parole violators from going back to prison and instead have them on GPS monitoring. The department's now projecting will only result in $1 million in savings, and we're still trying to determine why that measure wouldn't result in more savings as you would expect. For the revocation workload and caseload adjustments, those will be updated at the May revision, and we'll review the updated numbers then. With regard to the proposal that the department has to activate the Northern California Reentry Facility, this is one of the reentry facilities that were authorized through AB 900. It's the first one that the department plans to open. And we are recommending that the legislature reject this proposal. What the department's basically planning to do is to activate the facility early with 100 minimum support inmates. And they say that they would use these inmates to try to get the facility ready for full activation, probably in July 2011. However, the costs associated with doing this, the budget request is for $8.4 million for 100 inmates, works out to about $84,000 per inmate, which is significantly higher than what we currently spend per inmate. And in addition, these facilities, these reentry facilities, are primarily intended to rehabilitate offenders who are reentering into the community, and the inmates that they are proposing to activate the facility with are minimum security inmates who generally don't require as intensive rehabilitation programs and services. So it would require a very large investment, and we don't see any clear benefits in terms of doing this or activating the facility early. The department was provided funding last year after the May revision to keep the facility in a warm shutdown until it's fully activated. So we would recommend that you reject that proposal.
Okay.
Do you want me to keep going through the rest of them? Okay. The department has another proposal to expand the out-of-state bed program. They started this program in 2006 after the governor issued an emergency proclamation declaring that there's a state of emergency related to prison overcrowding. They began transferring inmates to out-of-state facilities. We currently have about 8,000 inmates housed out-of-state in Arizona, Mississippi, and Oklahoma. The department or the administration is proposing to expand that number by an additional 2,300 inmates, which would further alleviate overcrowding in the state prison system. We have a couple of concerns with this proposal. The administration has identified the costs related to the proposal. So basically, you'd be taking inmates from in-state facilities and shipping them out of state. So you would save money because you would have fewer inmates in state prisons, but then there would be the costs associated with putting them out of state. And the administration calculates that that would net to a net increase in funding is what they require of about $2.2 million in the budget year. And we actually went through their population request and calculated that it really totals to $4.4 million because there are certain ratio-driven positions that they did not include in the overall calculation. They are included in their overall budget request, but they're not bundled into this specific proposal. So the real augmentation would be $4.4 million. We do think it's over budgeted. For example, they're requesting overtime for custody staff to be present while inmates are screened for medical conditions prior to being transported. And they're requesting $547,000 for 2009-10 for this purpose, but they did not calculate this based on actual need for overtime. What they did was they were able to find some savings in the program because they're paying us. They were able to negotiate a slightly lower per bed diem rate, and they want to use those savings to fund the overtime, but the calculation doesn't take into account the actual need for overtime. And in addition, we would note that last year this committee expressed a lot of concern about the department's use of overtime and what was driving overtime, and the department still has not justified its overtime budget. So we would recommend rejecting the augmentations for overtime. In addition, we would recommend rejecting most of the positions related to the augmentation that are not directly related to the expansion of the program. So the department is requesting 31.1 positions for the out-of-state bed program, and in reviewing the justification, we found that a lot of the positions weren't directly related to the expansion. So for example, one of the positions that they're requesting is an executive assistant to support the COSEF chief, and it's not clear how adding 2,300 beds to the program drives new workload at the executive level to the extent that you would need an additional position. So we think it's over budgeted. And in addition, the administration is proposing to eliminate the sunset date on this program, which is currently scheduled for July 2011, and we would recommend that the legislature consider extending the sunset date but not eliminating it. So we would recommend approving the proposal to transfer the inmates, since it would relieve overcrowding, but to reduce it by $547,000 in the current year and $2.1 million in the budget year.
Okay.
And finally, the department has a request for local assistance augmentation. There's a couple of different programs involved in this request. First, there's one according to current state law, CDCR is required to reimburse counties for costs associating with holding inmates sentenced to state prison where the county has notified CDCR to pick up the inmate, and CDCR has failed to do so within 5 working days. And then the counties will start submitting invoices after that. Now, in the past, the counties had never actually submitted invoices to the state for this, so this is the first year in which we've actually incurred this expense. And initial estimates by the administration is that it will require about $10 million to cover these costs. They indicate they will update this at the May revision. Our concern is that it costs CDCR, based on the marginal overcrowding rate, to house an inmate about $63 per day, whereas we have to reimburse the counties $77 per day for these inmates. So to the extent it's possible for the department to pick up all of the inmates on time, we could save some money there. In addition, CDCR is also required to reimburse counties for the costs incurred when they hold parole violators pending revocation hearings. And there's been a backlog that's accumulated in this program, and it totals about $86 million is the backlog. And in addition, the administration calculates that an additional $15 million is required ongoing to the base for an overall augmentation of $107 million. Again, these figures will be updated at the May revise, but we would just note that in terms of the backlog, the state does have to reimburse the counties, but it's not specified in the law when the state has to do that. So you would have the option to stretch out those payments over a series of years.
Thank you. Thanks for going through all of them. Finance, do you want to have any comments on each or any one of these?
No, I think just in general that, we get 2 BCP requests from the department every year for the population, one in the fall and one in May revise. Everything gets looked at and reviewed again in the May revise, where we update it based upon new workload data, new data that has become available. The fall submission of the POP is typically based upon data only through September, maybe early October. So now we'll have a lot more data in which to refine the estimates for all these areas. As far as I do want to make a point on the local assistance one, especially the last one, related to possibly deferring payments out. We have to be careful in that area because we work really closely with the locals and they help us with our bed management. We also work with them really closely in terms of implementing Valdivia and the revocation process and the court requirements that we have to meet. To the extent that we stop paying them or we try to push out too far payments in advance, we could run into issues with bed availability at the local level that we desperately need to be able to meet court requirements.
Okay. Department have any comments?
Well, I would concur with the Department of Finance with regards to the local assistance. We would be concerned about deferring payments too long, just given the fact that they are incurring the cost currently. And the department is out of money right now for this year's local assistance, and we're deferring all costs that happen from now, all billings that happen from this point forward to the budget year. And I think keep deferring those costs, and local counties they could potentially close intake for parole violators, which would be a big concern from us from a Valdivia standpoint, but also from a local public safety standpoint, because the department really can't absorb all of that population into its institutions without some severe impacts to our reception center processing and other concerns. I think we are also concerned about the LEO's recommendation with regard to the out-of-state program, but I'll let Chief Deputy Secretary Terry McDonald address those.
Good afternoon, Senator. Terry McDonald, Chief Deputy Secretary, Adult Operations. I very much appreciate the LEO's perspective on what they're saying, but I don't think they fully understand that the state has asked for fewer than 250 positions to provide oversight for 10,000 medium security offenders in prisons out of state. We've been remarkably successful in not having any major incidents out of state, and that's a result of good and solid oversight. It requires staff to do that. These are not low-level offenders. These are offenders that they're medium security, level 3. We have level 4. We have administrative segregation. We have inmates that have been validated for SHU terms. This is a very complex program with a complex population. The state of California was also able to negotiate for medical care and dental care of these facilities. So to ensure that we're complying with the PLATA requirements and the Perez requirements and the Coleman requirements for lawsuits, we need staff to provide oversight for that. Our failure to do that will certainly jeopardize this program. This is, of all of the units that I oversee, and I have all adult prisons and all adult paroles, this is one of our most overworked units that we have. So the thought that we're going to add another 2,400 level 3 offenders without giving them the resources to do that is a recipe really for disaster for this organization. So I appreciate your consideration.
Well, just explain to me, and I appreciate the comments too, are there net savings taking these prisoners out of state? I mean, that's at least the optics on the, so some of this is counterintuitive to me, at least what I'm hearing.
So what as we move these level 3 offenders out of state, we take down non-traditional beds in state, gymnasiums, triple bunks, day room beds. So there's an offset savings, yes. And so bringing up 250 positions to send, and that's total, that's for the whole 10,000. We've taken down many more positions in the system associated with that. Now we also pay the contractor as well, though, so that offsets that savings.
Well, I guess I'm getting at is just what the net savings are. And at least in front of me, it has a comment that out-of-state beds are more expensive.
They're more expensive than the marginal cost of providing those services in state, but there's an assumption behind that there are really beds readily available in state. The problem with that is that due to our population, the way it's impacted, largely what we're talking about, as Ms. McDonald spoke of, are gymnasiums or really inappropriate housing options. It's probably marginally more expensive to house them out of state. The contract cost is generally, I don't remember what these are.
$61 to $73 a day.
Yeah, $61 to $73 a day, whereas the marginal cost for a prison inmate is around $63 a day, though it's been creeping up lately. So those costs are, it depends on which facility and what level, but they're in the same neighborhood, but it is slightly more expensive to house an inmate out of state.
So it would be fair to say that in the public's, at least some of the argument for this is that our staffing costs are so high that by shifting these people out of state where staffing costs are lower, that we're actually capturing savings. But when you take the total cost, that's not true.
Right, it's not true. But then you look at the jails. So if you're paying the local jail rate at $72 a day, $77 a day, if we don't have capacity in our system, they sit in the jails. So whether you're looking at our cost of overcrowding in a gymnasium where they don't belong, or we're paying a jail to house them, it's almost a wash from my perspective. The decision was not made for a cost savings to move the offenders out of state. It was made because the prisons were grossly overcrowded.
So as we go to early release and we start to remedy some of the overcrowding situation, does the need for out-of-state placements diminish?
Well, it'll depend. Probably not, largely because the inmates we're talking about in the out-of-state program are upper-level people that probably aren't the type of people that you would talk about in some sort of early release program. So, and it's also important to note that the cost of providing these out-of-state beds is significantly less than the cost if you were to add new facilities in-state as far as prisons, which would be roughly twice that cost. And so I think part of the consideration is if you were to build 2 new prisons, you'd be spending probably at least twice as much as this on the operation of those prisons. So.
Okay. On the reentry facility, does either the Department of Finance or the department have any comments on that? Mr. Lewis, you made an editorial comment with your face there.
I would just say we're still looking at the proposal. We still support, obviously, having a reentry facility in the Stockton area at the former women's facility, and that the administration is looking at what is the best activation for that at this time.
Okay. Well, we'll look forward to continued discussion. Okay. I guess on the local assistance, one thing, Mr. Lewis, is just how do you communicate with the locals? I assume that the bigger counties are the lion's share of the money, so Los Angeles.
Well, Los Angeles is well over half, actually, because we get a good chunk of our parole violators through there. I think that they're the most impacted county that we're speaking about. Largely, it's just we'll try and have deal through the statewide Sheriff's Association when we begin to run out of funds. So a couple of weeks ago, we had a conference call with the sheriffs to discuss what we were doing and also to point out our future and what we're trying to do this in the future. We're trying to be much more interactive and provide that information to them as quickly as possible. In the past, it probably just came as they didn't get paid, though.
Okay. Do you have an ability administratively to pull funds from somewhere else to help in the short term, or do you need our action? And
there's an administrative way to move funds from our main item to local assistance, but there is no actual savings in our main item that I think that we could redirect without causing a significant hole in the state operations budget. So those costs aren't things that we can defer to the budget year, whereas unfortunately for the locals, we can defer these local assistance costs.
Okay, so I thought maybe, excuse me, either from one or both of you, you intimated an urgency to this, that maybe we shouldn't leave it open to the May revision. Did I read that right? Or
no, we do want to leave it open to the May revision so that way we can come with the correct number. Okay. We don't want to come with a number higher than what we actually need, obviously.
No, we don't.
But also we have requested via one of the budget bill language to shift some money from the parole lease jail beds. There's some savings there over to the local assistance item in the current year to help a little bit, but it's only around $5 to $6 million, if I recall, and that's just a drop in the bucket of the backlog that we currently have. And we'll come forward with our formal request at the time of the May revision.
Okay.
Right. And just to be clear, the urgency isn't. I think the sheriffs are very concerned about not being paid for their services now, but the urgency comes from where the LAO is pointing out you could spread this cost over several years after that. You don't have to fix it all next year. Where the longer the payment terms are, the more concern that we would have. That's our urgency, not necessarily the deferral to the budget year.
I know what it's like to be pursued by a sheriff. And I'll refer him to the LAO.
And just as a last point on this issue, to be fair to the locals, we did pass trailer bill language about 2 years ago that required them to submit their claims in a timely manner, and so now they are complying with the law and submitting their claims within 6 months after incurring the cost. And whereas before they used to submit it well after 6 months, and then we'd get backlogs from a long time ago when we'd start to receive the claims. So now that they're submitting them more timely, we're starting to really see the underlying impact on this program.
Okay. So. Any other comment from Finance? Saw you move forward.
Yes, Nathan Johnson, Department of Finance. I just wanted to go back to the out-of-state beds issue, and we'd like to note that Finance also shares similar concerns with the LAO's recommendation. And we'd like to note that the base level of staffing for the out-of-state beds program was established when COSF just had 5,000 inmates scheduled to go out of state. Now this program is expanding to 10,000 inmates. And although it might not be directly related to this last 2,000, but the expansion from 5,000 to 10,000 has put significant strain on the current staffing levels within their program.
So what if we just said no? What would you do with those clients?
Oh, it really jeopardizes our ability. I think my recommendation would have to be, I'm not the final decider, that we don't expand the capacity. Because if we cannot provide oversight, it jeopardizes public safety and jeopardizes the program.
So where would those clients be? Where would those inmates be?
You'd be back in triple bunks, jails, the overcrowding conditions that we have. We simply can't take additional capacity without the staff to oversee them.
Okay. All right. Any public comment on this? What a surprise. Mr. Brown has something to say.
Craig Brown for CCPOA. Obviously, our interest is in the out-of-state beds. We're pleased that the administration finally admitted that these beds are more expensive than leaving these inmates in the state budget, contrary to representations of people in administration that they were saving money through this mechanism. Even the comparison they've done, we don't think takes a full accounting of the medical costs. The contracts limit the contractor to paying $2,500 per year for medical, and the rest of the bills come to the state and show up on the state side. We also think that there's an issue with transportation costs. These inmates are expensive. I notice you're missing Republican colleagues today, but I would point out that many of these Republican doors around here have a sign called California Jobs First, and this is a really fine program for jobs in Mississippi, Oklahoma, and Arizona, jobs that belong in California, paying taxes in California. My final comment would be, we recommend that you do not extend the deadline. You should not let this administration tie the new governor into a policy that he's going to be stuck living with to pay these bills when he may come up with a different way to incarcerate. He may be more willing to reduce population. It's simply inappropriate to tie a new administration for even one extra year into this. These contracts, the existing authority lasts through June of 11. The new governor has time to deal with this issue.
Okay, thank you, Craig.
Steve Kalmer on behalf of the Board of Supervisors for Los Angeles County. Just wanted to say that we would be concerned about any proposal to further delay the reimbursement on the jail beds.
Not surprising. Thank you. Okay, seeing no one else, that is our last item. We'll be in touch, and we'll be back, obviously, for follow-up meeting. Thank you all. Have a good weekend.
Hey.